Okay, good morning. Thank you for joining us today for our webinar. I think the start of the year is a good time to take stock, reflect, look at recent developments, and look ahead for charities in 2023. I'm pleased to be joined today by my colleagues, Carla Whalen, Employment Specialist, Alison Sadler, Specialist in Governance, Operational Commercial Matters for Charities, and Sam Morris, who's one of our property experts for charities. So during this webinar, you'll be able to ask questions if you'd like, and I encourage you to do so in the chat box, and we'll answer those as we go along, possibly at the end. And I should note this webinar is being recorded. So, just starting with setting the scene really, in preparation for this webinar, I looked at my notes from last year, and they talked about unprecedented charity challenges, and in many ways you can sadly repeat that this year, and perhaps say there's even more unprecedented charities as the sector has really moved from crisis to crisis, emerging from the pandemic only to be faced by the cost of living crisis as well. We've also been experiencing the sector inflation, rising costs at a time of reducing income and also high demand for charities and their services. So NCVO, in its Civil Society Almanac, published at the end of 2022, identified that the sector income had grown, but was slowing, and the gap between income and spending has narrowed. Also, some evidence now of reduced giving, with the squeeze on living standards and property prices reducing, which could have a detrimental impact on those charities that rely on legacy income so much. Research from Pro Bono Economics and Nottingham Business School recently found that 71% of social sector organisations report a rise in demand in the 3 months to November 2022. So a huge amount of pressure for charities at the moment. Looking into 2023, there still seems to be in many ways an uphill struggle for the sector, continued uncertainty, also a reduction in government support of energy subsidies, and a lot of uncertainty in that area. For a lot of clients coming towards the end of fixed term energy deals, and great deal of uncertainty about what the gas price, electricity price is going to be over the next 12 months, particularly charities with lots of properties. That can be a real challenge. Also still dealing with some inequalities that have been exacerbated perhaps by the pandemic. So turning to some of the sector themes and trends that we've seen from our practice and more generally over the last few months, and we see continue into the next year. So the ongoing so-called culture wars, the charities very much still seem caught up with this. Last year we had the RSPB launching a campaign with others, saying that the government who was launching an attack on nature, which resulted in a number of MPs in particular publicly criticising what the RSPB was doing, and things becoming quite politically contentious quite quickly. More recently, the Conservative MP Andrew Bridgen has been suspended from the Conservative Party for spreading misinformation about COVID vaccines, including some baseless allegations against a national charity. And it can be really challenging for charities that get caught up in this sort of stuff, where there can be social media, other communications very quickly dragging charities into it. So it's a trend that is continuing and difficult for the sector. I think one thing has shifted slightly is that charities are perhaps responding with a slightly greater degree of confidence. They accept this is the world that we're in and realise that they must focus on their mission, and if they're doing that, they can continue and withstand these challenges. And they have been withstood. For example, the National Trust, the Restore Trust campaign was effectively defeated at the ballot box at the National Trust's AGM last year. Also, the shifting political context. Do we remember the chaos of 2022? 2 prime ministers removed, political uncertainty and stasis, not at all helpful for the sector. It creates great uncertainty about what the policy framework is going to be. Things have perhaps settled down slightly now, perhaps with a slightly greater degree of certainty, but we're still in challenging times from a political perspective. Only yesterday, Lucy Fraser became the 8th Culture Secretary in 6 years, and she has overall responsibility for charity policy. So a real sense of flux at a political level, which is problematic. Also potentially some element of opportunity as we start to move towards the period of the run-up to the general election, which must be held by January 2025, and potential opportunities for charities to influence the manifestos of the parties at that election. Next little box is even more charity disputes. So the trend we've sadly seen lots of in recent years is an increasingly large part of our practice is supporting charities with disputes, not with third parties, but internally, disputes between trustees and members. Members being concerned about the direction the charity might be moving in. This is a trend that the Commission has identified too. What are the reasons for this? Probably quite complicated. I think there's some sense that the working practices in the pandemic, promoting greater remote working, online meetings, people not meeting so much in person, communicating more by email has not been helpful. But what it really highlights is the particular importance of good governance, and within good governance, managing people-related issues proactively, identifying and pick up on issues when they're at a more minor level before they can escalate. And again, think about how people communicate and doing it in the most effective way that reduces the risk of things becoming adversarial internally. Emerging impacts of Brexit. I think we're still learning exactly what Brexit might mean. There's been a lot of negative comments in the press recently about the economic impact in particular. There's a sense the pandemic might have masked some of the implications, challenges with staffing, economic impacts, which we're really starting to understand now. And there's still some element of uncertainty about how things will settle from a legal perspective. Approach to the Charity Commission. And there's probably some slightly more positive perspective here. Orlando Fraser was appointed as the chair earlier in 2022, and I think there's a general sense in the sector, and certainly we've seen this, that the Commission has a slightly better tone these days in terms of being more supportive of charity, but it's also very quick still to take regulatory action of all sorts, which can create real challenges for the sector. Still under pressure, still under-resourced. Also increasingly focusing on some of the operational activities of charities. At the moment, it has out some draft social media guidance when it's recommending that trustees set rules on employees' personal accounts, because comments they make on their personal Twitter, for example, could be seen to reflect the views of the organisation, which have been seen as quite understandably contentious about this. Where does the interest of the charity end and those of individuals begin? So with that, I will, and one of the, from a legal perspective, one of the big developments in 2022 was the passing of the Charities Act, and with that I'll pass to my colleague Alison, who will talk you through some of the developments.
Thanks, Chris. So the changes introduced by the Charities Act 2022 will not have a big impact on charities' daily operations, but should simplify certain areas of regulation for charities. The changes will be gradually implemented. The first round of changes came into force on the 31st of October 2022, and all other provisions should be enforced by autumn 2023. Today, I'm just going to talk about three key changes. They will be failed charity appeals, permanent endowment, changing purposes and amending governing documents. So starting off with failed charity appeals, charities often make appeals to raise money for a particular project. For example, a charity might look to raise money to fund a medical procedure for a child in the Philippines, and charities often encounter two problems with this type of appeal. If the charity raises too much money, how should the charity deal with the extra funds? That's known as surplus cases. Or if the charity doesn't raise enough money to carry out the procedure, what should they do with the funds that they have raised, known as initial failure? Prior to 31st of October 2022, the rules were quite cumbersome and they weren't that well used. The previous rules provided that the funds belonged to the donor and needed to be returned. The Charity Commission could make a side-praise scheme to change the purposes of that the funds could be used for, but only after trustees contacted donors and those donors agreed that the charity did not need to return their donation and gave other donors a chance to come forward. A new power has been introduced for both initial failures and surplus cases. The trustees, in line with certain conditions, are now able to apply funds for new purposes rather than having to seek consent from the Charity Commission for a side-praise scheme. Where the funds exceed £1,000, Charity Commission consent will be required for the trustee resolution to take effect. If the fund is £1,000 or below, the administrative burden will be lifted and Charity Commission consent will not be required. In the case of initial failures, before the trustees can use this new power, there are some additional administrative requirements that need to be met. These will allow the funds to be applied side-praise for new purposes if the donations are small, up to £120 in a year, unless the donor has specifically stated otherwise. The trustees take reasonable steps agreed in advance with the Charity Commission to contact donors to offer return of their donation. The donations are raised through a cash collection or from a lottery, competition or similar. The Charity Commission decides it would be unreasonable to take steps to contact the donors because the cost would be disproportionate to the funds, or it would be unreasonable for the donors to expect it to be returned. This is all really good news for charities. However, all of these issues could be avoided if you're really careful about what you put in your fundraising literature. You need to make it clear to donors that if you raise too many funds or too little funds, that funding would be applied to the general purposes of the charity. So moving on to permanent endowment. Many charities hold funds which are subject to restrictions in relation to how it can be spent, including permanent endowment funds. Permanent endowment funds is where the capital of the fund can be invested and only the income generated from the investment can be spent on the purposes of the fund, which is often narrower than the purposes of the charity. Over time, charities find that the purposes of their funds have become out of date, or the permanent endowment fund can no longer generate sufficient income to justify the cost of administering it. In some cases, the governing documents of the funds will contain an express power to change the terms of the fund. More often though, charities which wish to spend their permanent endowment have to use statutory powers to decide to remove the restrictions on spending the capital subject to certain conditions. For larger funds, those funds with income of more than £1,000 and a market value of more than £10,000, the decision to spend permanent endowment is subject to Charity Commission consent. But no Charity Commission consent is needed for funds with a market value of £10,000 or less, or the income of £1,000 or less. From spring 2023, the requirement for Charity Commission consent will be determined by one financial threshold based on the value and not the income of the permanent endowment fund. And this threshold will be increased from £10,000 to £25,000. The aim is that this will simplify the operation of the statutory powers and enable more charities to spend smaller permanent endowment funds without the bureaucracy and cost of seeking Charity Commission consent. Also, under the new rules, the time limit for the Charity Commission to respond will be reduced from 3 months to 60 days. So hopefully you'll be getting some quicker responses from the Commission. Another new power is around permanent endowment is borrowing. There will be a power for charities to borrow from their permanent endowment subject to a limit of 25% of the value of the endowment funds and repayment within 20 years without having to obtain consent from the Charity Commission. There are a few grey areas in relation to this proposed new power, but it's hoped that some of them will be clarified by the guidance that comes out from the Commission. Finally, in relation to permanent endowment, there's some changes around social investment. For charities which have opted into the total return regime, there will be a power to resolve that permanent endowment may be used to make social investments with a negative or uncertain financial return. Again, this is subject to regulations from the Charity Commission, so it remains to be seen how this new power will be applied. Given these changes, we suggest that you have a look at your permanent endowment funds now and see if they're working effectively for you, because it may be that you can make some changes under this new legislation. Finally, I'm going to be talking about changing purposes in your governing document. In autumn 2023, the relevant provisions in the Act will come into force, and it will change the rules on amending governing documents for charities, which are companies or CIOs. The idea behind the changes is to align the rules across all the different legal forms of charities. For corporate charities, the existing regulated alterations regime will continue to apply. So you'll still need consent from the Charity Commission to make changes to your purposes, your dissolution clause, and any provisions relating to trustee or member benefits. Currently, the legislation does not set out a test for what the Commission is supposed to consider when looking at requests to change purposes in a governing document. The guidance from the Commission says that it will check that the new purposes are exclusively charitable, that the decision to make the change is a rational one, given the circumstances of the charity, and that the new purposes do not undermine or work against the previous objects. The Charities Act 2022 will introduce a new statutory test, which the Commission will have to apply when considering whether to give consent to a request to amend charitable purposes. The new test requires that the Commission is to have regard to One, the purposes of the company or CIO when it was established, if and so far as they are reasonably ascertainable. Two, the desirability of securing that the purposes of the company or CIO are so far as reasonably practical, similar to the purposes being altered. And three, the need for the company or CIO to have purposes which are suitable and effective in light of current social and economic circumstances. In light of this, trustees of charitable companies and CIOs who are considering making amendments to their constitutions should consider whether or not they want to press ahead with these changes now. It's on the face of it, it does seem that this new test that's being introduced is a lot stricter, especially because the Charity Commission will have to have regard to the original purposes of the charity. So I've just briefly talked about 3 areas of change under the Charities Act today, but there's obviously a lot more provisions, and we have a few articles on our website that go into a bit more detail, and we will continue to update you as provisions come into effect through our charity bulletin. But now I'm going to hand over to Carla, who's going to talk about employment law and data protection.
Thanks. So I think we've got about 5 minutes on data protection, 5 minutes on employment law changes, so I'll do my best. I think I had expected that data protection, what's new for 2023, would be all about the new Data Protection and Digital Information Act. In the middle of last year, we got the DPDI bill published. It all looked pretty good. This was going to be the kind of UK replacement for the UK GDPR. Quite a few of the proposals were quite exciting for charities, most notably, I think, extending what we call the soft opt-in for electronic marketing to charities. Currently only applies to corporates, and that's quite annoying for charities, particularly in the fundraising area. That hit a real bump in the summer, kind of around party conference season. The brief Liz Truss government, the Tory party conference, they kind of said, oh, we're going to do something quite different actually with data protection law. There's going to be a new British data protection law. And that suggested actually there's going to be some quite wholesale changes perhaps to that bill. So really nothing's much has happened since then. There was meant to be a second reading in September. It didn't happen. Department for Culture, Media and Sport have given some indication that there'll be another kind of mini consultation at some point early this year on changes to that bill. We don't really know what's going to come in that respect. All we have now is a promise of a bespoke British data protection system. So make of that what you will. So instead, I'm actually going to talk about things that definitely are happening in 2023, and we'll just keep an eye on the progress of that bill. So firstly on here, I put the direct marketing guidance. So a couple of years ago now, the ICO published a draft version of the Direct Marketing Code of Practice, which is something that the Data Protection Act 2018 said they sort of had to introduce. But we've never seen the final version of it. So we've kind of been working off this draft document. Because of the delays I just mentioned with the data protection, the new Data Protection and Digital Information Act, the ICO has basically just put out some updated guidance on its website and said that will form the basis for the new code as and when the DPDI Act is kind of sorted. So there's some really quite important things and really useful things in that new guidance for charities, particularly again around fundraising, social media, marketing activity, profiling, the million-dollar question, what's a service message and what's a marketing message? There's guidance on all of those things, so definitely I'd say take a look at that. The second kind of what's new for 23 in data protection point is around employee data. 2 different consultations from the ICO towards the end of last year in the autumn, one on new guidance on monitoring at work, so monitoring employees, again, something that really kind of increased as a question in the pandemic when there was much more remote working and quite a few employers were wanting to monitor remotely. And also consultation on processing employee and worker health data, including things like, you know, what's the appropriate lawful basis for that, and questions around appropriate retention periods. So both consultations closed just last month in January, so hopefully we'll see the final guidance coming out before too long. And then finally, no one wants to talk about international data transfers because it's frankly still a little bit of a mess, but 2022 did bring some clarity. For those interested in this area, you will remember we had Max Schrems, the German privacy campaigner, bringing his second challenge in the European courts a couple of years ago, which really then required the European Commission to issue new model clauses, so those standard contractual clauses that we were using to transfer personal data outside of the EU, and particularly the focus in those cases was on transfers to the US. Also, at the same time, that case brought down the US-EU privacy shield, which was a kind of really quite seamless way of transferring data. So it took a while for us to get the kind of the new model clauses that we needed, but last year the EU did issue its new model standard contractual clauses. And at the same, similar time, the ICO published the UK International Data Transfer Agreement, or IDTA, and it also published a kind of addendum that could be used to the append to the EU standard contractual clauses. So if your charity operates across the UK and Europe, and you've already got those European SDCs, standard contractual clauses in place, you can just use the UK addendum rather than having to do an entirely separate document. So it's quite technical. There's quite a bit of guidance on already around, but the ICO has promised that we'll be getting clause by clause guidance very soon on that IDTA. Again, the fallout from the Schrems 2 case, there was also a requirement to do a transfer risk assessment before transferring data outside the EU. And so there's a template TRA, or transfer risk assessment, that the ICO published. That only came out in November, and we already hear that the ICO is going to issue some additional guidance and examples of how to use it, because I think, frankly, people are struggling a bit. So that might look like we're making good progress. There's also a kind of Privacy Shield Mark II, which is making its way through the European Commission. There's a framework that just needs to be approved, and then we can expect a UK version pretty soon after that. Unfortunately, Max Schrems has indicated Schrems 3 is just around the corner. He's going to challenge that framework before the Commission's even approved it by bringing another case in the Court of Justice of the EU. So this is just going to rumble and rumble, and unfortunately for people hoping for clarity, it's probably not going to come really soon in 2023. So let's move on to people. So on the sort of people employment side of things, one really big development last year was the case of Harper Trust against Brazel. That was a holiday pay case. It related to casual workers. And in summary, it said all workers are entitled to 5.6 weeks holiday a year, even if they only work for part of the year. So this was a case about term time workers in a school. And crucially, it said casual worker holiday pay shouldn't be prorated, and that the old way of using a sort of percentage of 12.07 to calculate holiday pay for casual workers was wrong. That kind of led to a lot of people scurrying to look at their policies and how they calculate holiday pay for casual workers, and then in a lot of cases making changes. To the kind of dismay of some of those organisations that had spent a lot of time grappling with this and making changes. Just last month, the government has launched a consultation, and guess what? It proposes to change the working time regulations to permit the use of the 12.07% calculation for casual workers. So if you haven't already looked at Harper Trust, and applied it to your casual workers and made changes, I think it's possibly worth considering whether you want to make permanent changes now, or whether you want to kind of try to reach an agreement with your staff that you will keep this under review. We're very happy to talk about this further. It's something that we've been speaking to a lot of charities about. EDI, Equality, Diversity and Inclusion, and ESG, the slightly newer acronym on the block. So that's environmental, social and governance. both kind of still very much things that we hear a lot of charities focusing on, thinking about their sort of policies, but then also crucially kind of setting targets, publishing what they intend to do, and then really holding themselves to account on how they're progressing. Discrimination case law is always lively, and last year we had a couple of quite interesting cases for charities. One was the Scottish Federation of Housing Associations. That was about dismissing someone because allegedly unfairly because of their political views. In that case, actually, this was an employee who was dismissed after she said she was going to stand for Scottish Labour as an MP, I think. And the Federation of Housing Associations dismissed her because they had a policy of political neutrality. So what's I think interesting there is the Employment Appeal Tribunal said, no, she wasn't actually dismissed because of her political beliefs. She was dismissed because she didn't adhere to their policy on political neutrality. So it didn't really matter which political party she had intended to run for or that she was aligned to. It was about the political neutrality point rather than her political opinions, which I think draws quite a bit of a tighter kind of line around what we mean by dismissed for political opinion than we previously thought, but could be quite helpful for charities who are obviously trying to also stay on the right side of charity guidance on political neutrality. We had some cases on the menopause. Menopause was something that got quite a bit of attention in the last couple of years with the House of Commons Women and Equalities Committee suggesting that there should be legislative changes to require employers to make changes to support people going through the menopause in the workplace. That's not going to happen. The government has said that they're not going to do that. But because we've had these cases going through the employment tribunals, it is really clear now that a person going through the menopause can be protected as disabled under the Equality Act if symptoms that they're suffering affect their day-to-day life and they meet that test. So even though we're not going to see statutory changes in that sense, there is now a really clear obligation on employers to treat symptoms arising from the menopause as you would any other condition that has an effect on people's day-to-day life. Flurry of cases on trans rights and protection of gender critical beliefs continues to be obviously a really hot topic, very tricky one within and well beyond the charity sector. Case law doesn't give us a huge amount of certainty. We had two cases, the Forstater case and the Bailey against Stonewall case, which concluded that the claimants there had suffered discrimination because of their gender critical beliefs, which were protected as a philosophical belief under the Equality Act. But we had two other cases which kind of illustrated the limits of the protection that employees get around those philosophical beliefs. One was about a doctor who was dismissed for refusing to use a trans person's pronouns of choice. That was McCareth. And then there was another case, Higgs against Farmers School, where so a school administrator using inflammatory language in Facebook posts, which could have led readers to believe that she held sort of homophobic and transphobic views, that it was fair to dismiss her. Those cases are being appealed, so 2023 might see an update on those conclusions. And so it's just one of those issues that we are just going to have to keep quite a close eye on. So I started with the Data Protection Digital Information Bill, and I'm ending with a different bill which potentially could have wide-ranging effects on employment law if it proceeds as expected. That is the retained EU law revocation and reform bill. So this is the one that's been in the news a bit recently, where the government is basically proposing a sunset clause. So all EU law on the statute books would expire on 31st of December this year, unless it's expressly preserved by ministerial order. I think it's quite telling that the government is still in the process of trying to work out what EU laws we have, and there's a web page that they update regularly when they find a whole new raft of EU laws. So this is quite a tricky one. In the employment sphere, it could potentially impact on a lot of the sort of central pillars of employment law, including the ones we've just been talking about. So things like working time regulations, agency worker regulations, fixed term employee regs, and also a lot of TUPE, the transfer of undertakings regulations. So it had a pretty rigorous second reading in the House of Lords recently, and it's possible that we might see some changes to that idea that everything goes on the 31st of December unless it's expressly retained. But that's going to be a real watch point, I think, for all of us this year. So I think that's quite enough to get to grips with. I will now hand over to Sam.
Thanks, Carla. And on the property side of things, there are various changes to property law, and the Charities Act 2022 in particular is bringing in significant changes to the way that charities can lease or sell land that they own. So currently, under the existing regulation, there's a restriction on charities disposing of land, so transferring land, selling it, leasing it, without first obtaining what's known as a qualified surveyor's report. And the charity has to instruct a RICS qualified surveyor, consider that report, and follow any advice that's given in the report, including advertising rules and things like that. And the principle behind this is essentially to ensure that charity trustees are always acting in the best interests of the charity, and most importantly, not getting rid of valuable historical real estate assets that have been in the charity for many generations at an undervalue. However, the 2022 Act acknowledges that this approach has not always been the best way for each transaction. So there's not sort of a one size fits all, and it's also not fitting really for some transactions. So many routine transactions, and even we've seen cases where a charity is surrendering a lease and they know they can't afford it, and it's obvious why they need to get rid of the lease, but they still have to go through this process of obtaining this specialist report, considering what's in the report. And so the changes under the 22 Act provide trustees with a bit more flexibility with this process. And they will now have the choice of appointing what's known as designated advisors rather than the traditional RICS surveyors to prepare these reports. So a designated advisor, it simply needs to be someone who the trustees reasonably believe has the expertise and knowledge to advise in this given area. And that could be someone in-house. It could be a trustee who perhaps is a land agent or an estate agent, or it could be a property manager on staff or someone like that. So there will be a bit more flexibility here. That being said, in some of the more complex transactions, the appointment of the traditional RICS surveyor may still be preferable, where there's certain levels of complexity, and so there won't be a kind of one size fits all with this. Is ultimately charity trustees need to be able to justify their actions to the Charity Commission if called upon. So where there are complicated transactions, having that assurance of the traditional report may be beneficial. But nonetheless, it's hoped that this change will help, and there may be cost savings, time management, things like that. And so that's a positive change. In addition to surveyor reports, charity employees will no longer be considered connected persons, where a charity is planning on letting out property that they own to that employee, where it's for a tenancy of a year or less. So previously, in order to do this, there would be a very complicated process. You'd have to get consent from the Charities Commission and so on. And not every employee can fit quite easily into the license occupancy agreement, where they, for example, they need to live on site as part of their job or as part of their contract. So in these cases, charities can potentially offer the usual AST to an employee going forward. On a more general property update, the big change coming in 2023 is something that will most likely affect charity landlords. And this is a change to the minimum energy efficient standard, so known as the MEES regulations. And these regulations are the regulations underpinning the EPC certificate. So when you let out a commercial building or a residential building, you need to have an EPC certificate. From the 1st of April 2023, for commercial buildings, there will be a minimum certificate rating requirement of F or G. So if you fail to achieve an F or G rating, then there can potentially be big fines based on the rateable value of the property. It could be even up to 150,000, what we're told. And so it's important that if you are a charity landlord, you take stock of what your current EPC rating is. In the short term, there may be some relief available if you carry out improvements and this does not improve the rating, then there's some leeway with that. Or, for example, if you simply cannot get access to the property to carry out improvement works because the tenant won't let you in, there should still be some leeway there. However, going forward, there's an energy white paper published in 2020 and confirming really that the future trajectory is going to raise the bar even higher for landlords. And commercial buildings from 2027 are likely to need a rating C, and by 2030 a rating B. So if you're a charity landlord and you're planning on letting out your, doing a commercial lease for 10 years or 15 years, you need to make sure that you at least you have this on your radar in terms of the energy efficiency of your building. And so one way of doing this is just ensuring that there are clauses in the lease which allow you access to carry out these works, and just making sure that you have something in the lease to account for this. Charity tenants can also be affected by this, and as I was saying, with a commercial lease, it may be that a landlord is trying to sneak in these improvement costs or works onto the tenant. So that may come under the service charge. It may be an express clause in a lease where the tenant is responsible for carrying out these improvement works. So charity tenants should also be a bit wary of this going forward. Ultimately, that will come down to negotiation, but it's important that charities are kind of aware of these risks. Finally, the Register of Overseas Entities. So this came into force on 1st of August 2022, and it brings in new regulations for overseas entities who want to buy, sell, or lease land in the UK. And they must, going forward, register with Companies House and ensure that Companies House is aware of the beneficial owners of that entity. And so these rules will apply to charities who have separate legal personality and are governed by law of a country or territory outside the UK. These rules do apply retrospectively. So if that applies and you bought land before 1st of January 1999, or disposed of land after 28th February 2022, these can apply retrospectively. Failure to do so could be fines or other sorts of penalties and restrictions in buying, selling, leasing land in the UK. Now for a brief market overview. So in terms of the position of the property market and the charity sector in particular, it's no different than the economy as a whole, facing rising costs of utilities, credit crunch, rising interest rates. For this reason, we have seen some charities looking to sell perhaps historic freehold land that they've owned to free up cash for other activities, and which might otherwise be tied up in real estate. And one famous example that's actually in the national news at the moment is the proposed sale of the Trafalgar Manor estate in Cornwall by the Gerald Cogengan Trust. And so we are seeing these. However, at least anecdotally, I'm seeing the market quite buoyant, particularly the commercial lettings market in central London. And I've seen a lot of new charity lettings so far this year. So charities may be looking for more creative workspace solutions, hybrid working. I'm seeing deals with inclusive costs for utilities and service charge. And the other thing that I'm noticing a lot recently is instead of leases, license agreements. So taking on desk licenses for say 10 or 15 desks, which just gives that flexibility of office, home working and office works. And charities may even see the changes with the 2022 Act on disposal rules as an opportunity to potentially have a bit more freedom in selling or leasing out property that they own. So all in all, for now, the market, from my perspective anyway, seems relatively stable. And I'll just hand back over to Chris.
Great, thanks, Sam. So just to round up the webinar, I'm going to provide a brief overview of some charity developments to look out for in 2023 from sort of legal and regulatory perspective. So on these, an enhanced role for Companies House. For those charities or trading subsidiaries that have the legal form of a company, used to dealing with Companies House essentially as a repository for documents. The Companies House doesn't have a particularly active regulatory role in the way that, for example, the Charity Commission does. That's set to change with the passage of the Economic Crime and Corporate Transparency Bill, which is looking at trying to prevent misuse of companies for criminal purposes. But it will have an impact on charities, ID verification requirements for directors and others. As I say, Companies House taking on this more proactive regulatory role. So there will be some additional compliance that comes from that. Procurement, lots of charities, particularly those that work with public bodies, receive funding from local authorities and the like, will be used to participating in procurement exercises. Procurement regime is changing. There's a procurement bill going through Parliament, which will change the way that public bodies commission and contract for services, something we'll be looking at closely and providing our clients with updates on. Charity Governance Code. It's actually been a great success in the sector. Lots of charities now measuring their own governance against that code. It's due for a review this year, particular focus on areas such as wellbeing and cyber as developments on the last version of the code. So that's certainly something worth looking out for. Public Order Bill. Lots of charities involved in campaigning, similar activities, potentially concerned about this. It's quite controversial and introducing what's known as serious disruption prevention orders, which will enable the police to restrict individuals from not associating with some people, prevent them from going to certain places and carrying certain items. So there is a real concern this could have a chilling effect on certain kinds of campaigning and protest. So from the Charity Commission, a load of new guidance coming from them, something expected on their charities and investment guidance and update, particularly in light of the case last year, looking at charities making ethical investments using ESG criteria, also update the social investment guidance at the same time. Charity Commission is about to introduce a new My Charity Account service, which is intended to be an easier and clearer interface between the Charity Commission and trustees and charities. It's going to be optional, but it's due to be rolled out in the spring, so something to look out for, particularly for charities that need to deal with the Commission more regularly, be it changing trustees, providing other information. Commission's also just updated its annual return with a series of new questions for charities with financial years ending 1st January this year or later. Commission's also promised this year some updated guidance on refusing and returning donations, which can be quite a complicated area, and charities can get caught up in some quite difficult issues, particularly if there are some donors who might be controversial. One interesting thing here, there's a judicial review that's taking place of the Charity Commission's statutory inquiry in relation to Kids Company. It's quite interesting. It's quite rare for the Charity Commission to be subject to a judicial review of any kind, and it's going to be looking particularly at the Commission's processes when conducting a statutory inquiry. So it can have real implications in terms of the Commission's regulatory role. So certainly something we'll be keeping a keen eye out for. And to end, an example of quite an interesting legal challenge, Mermaids, a charity which brought a challenge in the Charity Tribunal in relation to the Charity Commission's registration of the LGB Alliance as a charity in April 2021, with Mermaids alleging that LGBA existed to denigrate those who supported trans people. So that is part of a much wider debate, but is focused on the charity sector. So again, the Tribunal has been looking at the Charity Commission's registration processes, and it might have interesting things to say about how it does that and the basis on which the Commission makes decision. And that Tribunal decision is due quite soon. And again, we'll provide an update on that in our charity bulletin. So with that, I round up the formal bit of the webinar, as it were. So if there's any questions you like answering, do pop them in the Q&A now. Thank you for listening and joining us.